Before we begin, a quick and important disclaimer. The following content is for educational and entertainment purposes only and does not constitute legal, financial, or professional advice. Marriage laws, divorce proceedings, and asset distribution vary significantly by jurisdiction and are subject to change. The historical trends and case studies discussed are intended to provide context and understanding of a complex social evolution, not to guide specific legal actions. Viewers are strongly encouraged to conduct their own due diligence and consult with the licensed legal professional or qualified advisor regarding their unique circumstances. In 1920, if you wanted to end a marriage in the United States, you practically had to prove a crime had been committed. You were trapped in a legal cage where the only keys were adultery, extreme cruelty, or total abandonment. Fast forward to the present day, and the landscape has shifted so violently that the very definition of a successful marriage has been rewritten. We are living through what historians call the century of change, a 100-year pivot that transformed divorce from a social death sentence into a multi-billion-dollar industry and a fundamental right of individual autonomy. But there is a specific number that haunts the archives of American family law: 661. This represents more than just a statistic. It is a gateway to understanding how the legal machinery of the U.S. government moved from gatekeeper of the nuclear family to the arbiter of its dissolution. Most people believe they understand why marriages end, but they are looking at the surface. They see the arguments and the infidelity, but they miss the tectonic shifts in tax codes, property rights, and the no-fault revolution that fundamentally altered the American DNA. If you do not understand the history of this evolution, you are essentially flying blind through one of the most high-stakes legal environments in the modern world. This masterclass is designed to solve a critical problem for the modern U.S. audience: the lack of historical and legal literacy regarding the institutions that govern our private lives. Today, we are peeling back the curtain on the first era of this transformation. We are going to explore why the system was originally built to be impossible to escape, how the economic pressures of the Great Depression forced the first cracks in that foundation, and how the post-war era set the stage for a legal explosion that no one saw coming. By the end of this deep dive, you will possess a sophisticated understanding of the historical trends that shape modern domestic relations, allowing you to view your own legal and social standing through a lens of data rather than emotion. To understand where we are, we must go back to the beginning of this century-long journey. In the early 1900s, divorce was not just a legal hurdle, it was a moral catastrophe. The prevailing legal theory was based on fault. For a court to grant a decree of divorce, one party had to be innocent and the other guilty. This created a perverse incentive structure. If both people wanted to leave because they were simply unhappy, the law forbade it. This led to a phenomenon known as collusive divorce, where couples would literally hire actors to pose as mistresses or manufacture evidence of cruelty just to satisfy a judge's requirement for a guilty party. Case studies from the 1920s reveal a bizarre underworld of private investigators and staged hotel room raids. Imagine the cost, both financial and psychological, of having to prove your spouse was a villain just to regain your personal freedom. The economic impact of this era cannot be overstated. During the 1920s, the flapper era brought a temporary surge in social liberalization, but the legal system remained rigid. Property rights were heavily skewed. In many states, the concept of community property was a distant dream. When a marriage ended under the fault system, the guilty party often lost everything. This wasn't just about ending a relationship. It was about potential financial ruin. We see historical trends in this period where women, in particular, were trapped in abusive situations because the legal threshold for extreme cruelty was set impossibly high. You didn't just need to be unhappy, you needed to be in physical danger, and even then the burden of proof was on the victim. Then came the Great Depression. This is where our deep dive takes a fascinating turn into the intersection of macroeconomics and family law. You might assume that a national economic collapse would lead to more divorces as stress mounted, but the data shows the opposite. Divorce rates actually plummeted during the early 1930s. Why? Because divorce was a luxury. The filing fees, the legal representation, and the subsequent need to maintain two households were financially impossible for a population facing 25% unemployment. Instead of legal divorce, America saw a massive spike in desertion, the poor man's divorce. Men would simply leave, heading west or to different cities to find work, never to return. This created a massive legal vacuum. Thousands of women were left in a state of marital limbo, unable to remarry, unable to claim benefits, and unable to move forward because the legal system had no mechanism to handle a marriage that just stopped. As we examine the 661 framework, we see how the government began to realize that the fault system was failing the reality of American life. The step-by-step evolution of these laws began with small incremental changes in state legislatures. New York, for example, remained one of the most restrictive states for decades, only allowing divorce on the grounds of adultery. This led to the rise of divorce tourism. If you were wealthy enough, you traveled to Reno, Nevada, where the residency requirements were short and the grounds for divorce were liberal. This created a two-tiered system of justice in America. One for the elite who could afford to travel for their freedom, and one for the working class who were bound by the rigid statutes of their home states. The potential outcomes of staying in a broken system during this era were grim. We have historical records of migratory divorce, cases where the validity of a Nevada divorce was challenged in a home state like North Carolina or New York. This resulted in legal bigamy, where a person was considered divorced in one state but still married in another. This legal chaos forced the Supreme Court to intervene, leading to landmark decisions regarding the full faith and credit clause of the Constitution. This is a crucial point for our masterclass. The evolution of divorce isn't just about family. It's a battle over state versus federal power. Consider the case study of Williams versus North Carolina in 1942. This case changed everything. Two individuals moved from North Carolina to Nevada, stayed for 6 weeks, got divorced from their respective spouses, married each other and moved back. North Carolina promptly arrested them for bigamous cohabitation. The legal fight that followed reached the highest court in the land and set the precedent for how states must recognize each other's legal decrees. This started the slow crumble of the fault wall. It proved that if the law doesn't adapt to the needs of the people will find a way around the law. As we move deeper into this century of change, we begin to see the psychological shift. The 1940s and the onset of World War II brought a hurry-up culture. Marriages were rushed before deployments. When the soldiers returned, they found they were married to strangers. The post-war era saw the first major divorce spike in U.S. history. The legal system was overwhelmed. Judges who were used to handling a few dozen cases a year were suddenly faced with thousands. This pressure cooker environment is what eventually led to the 1960s and 70s revolution, but the seeds were planted in these early decades of struggle, fault, and economic necessity. In the next part of this deep dive, we will examine how these early failures led directly to the creation of the modern no-fault statutes that dominate the landscape today. We will look at how the 661 designation began to appear in legal codes as a way to categorize the irreconcilable differences that the law finally had to acknowledge. This isn't just a history lesson. It is a blueprint of how the American legal system reacts when social reality outpaces traditional morality. We are going to look at the data of the 1950s golden age and reveal the hidden cracks that were already forming under the surface of the suburban dream. Stay with us because the transformation of the American family is about to accelerate. The cracks in the suburban dream of the 1950s were not just social. They were systemic failures waiting for a catalyst. To understand why the 661 phenomenon matters in 2026, you have to look at the life of someone like Sarah in 1958. Imagine Sarah living in a pristine Levittown home. On the outside, she is the image of post-war prosperity. On the inside, her marriage has been functionally dead for 5 years. In 1958, Sarah is legally tethered to a man she no longer knows. Under the laws of the time, she cannot simply walk away. If she wants a divorce, she has to enter a legal arena where she must prove a specific, codified fault. If she cannot prove adultery, physical battery, or desertion, a judge has the power to deny her request and force her to remain in that household. This was the era of the marital trap, where the legal system prioritized the preservation of the contract over the well-being of the individuals within it. Historical trends from this period show a terrifying rise in what sociologists call the captive wife syndrome. Because the legal threshold for cruelty was so high, many women were forced to endure psychological warfare that did not leave physical marks, as those marks were often the only evidence a 1950s court would accept. The potential outcomes for Sarah were limited: stay and suffer, flee and lose all rights to her children and property, or engage in the humiliating spectacle of a staged divorce. This is where the 661 story begins to take shape. The sheer volume of people trapped in these legal fictions created a massive underground demand for a better way out. While the 1950s are often romanticized as a period of stability, the data tells a story of mounting pressure. By the early 1960s, the divorce rate was beginning to climb, despite the laws remaining static. This was the era of the Reno cure. Imagine if you had the means to leave your life in New York or Chicago for 6 weeks, just to satisfy a residency requirement in Nevada. Tens of thousands of Americans did exactly that. They flocked to Reno because Nevada had discovered a lucrative business model: short residency and liberal grounds for divorce. This was the first iteration of the streamlined divorce, a precursor to the efficiency we see in 2026. But for the average American who could not afford a 6-week vacation in the desert, the legal system remained a wall. Step by step, the pressure moved from the households to the courtrooms. By 1965, judges were becoming increasingly frustrated with the perjury occurring in their courtrooms. Couples who both wanted to end their marriage were forced to lie under oath, claiming one party had committed a fault that never happened. This was a direct threat to the integrity of the U.S. judicial system. It created a culture where the law was something to be navigated and manipulated, rather than respected. The legal machinery was grinding to a halt under the weight of its own hypocrisy. The year 1969 represents the most significant pivot point in this century of change. In California, a landmark piece of legislation was signed into law that would eventually ripple across all 50 states. It was the Family Law Act of 1969, signed by Governor Ronald Reagan. This was the birth of no-fault divorce. For the first time in American history, a spouse could walk into a courtroom and state that the marriage was over due to irreconcilable differences. No villains were required. No staged hotel room photos were necessary. No private investigators needed to be hired to tail a spouse. Imagine the shift in the room when that law took effect. Suddenly, the power dynamic shifted from the state to the individual. But this wasn't just about making it easier to leave. It was about the economic fallout that followed. When you remove the need for fault, you also change how property is divided. The historical trends shifted from a system where the innocent party was rewarded with the house and the savings, to a system of community property and equitable distribution. This had massive financial implications for the American middle class. In our 2026 context, we look back at this as the moment the floodgates opened. Between 1960 and 1980, the U.S. divorce rate more than doubled. This was not just a legal change, it was a cultural explosion. The number of divorces per 1,000 married women jumped from 9.2 to 22.6. Think about that volume. The court systems were not prepared for a 145% increase in caseloads. This is where the need for efficiency, the very concept embodied by the 661 framework, became a necessity rather than a luxury. Case studies from the 1970s reveal the chaos of this transition. We see families who were the first to navigate these new waters, often without clear guidelines on how to handle child support or alimony in a world where no one was officially to blame. The potential outcomes were often unpredictable. Without a guilty party to punish, judges struggled to determine who should provide for whom. This led to the creation of the first standardized child support formulas and the professionalization of the divorce industry. Now, compare the experience of Sarah in 1958 with a hypothetical woman named John in 2026. If John wants to end a marriage today, the process is largely administrative. In many jurisdictions, especially in places like California where the 661 legacy is strongest, you can handle the majority of the paperwork electronically. The system has moved from a moral tribunal to a bureaucratic clearinghouse. The focus is no longer on why the marriage ended, but on how to move the assets and the people into their next phase of life as efficiently as possible. However, this efficiency came with a hidden cost. By making divorce a unilateral right, the U.S. government essentially deregulated the family unit. The economic data from the late 20th century shows a clear correlation between the rise of no-fault divorce and the feminization of poverty. In the old system, a stay-at-home mother had the leverage of the fault requirement to negotiate a better settlement. In the no-fault era, that leverage vanished overnight. A husband could leave regardless of his wife's wishes, and the court would simply divide the remaining assets 50-50, regardless of the woman's future earning potential. This brings us to a critical realization. The century of change was not just about freedom. It was about the commodification of the family. As we moved into the 1980s and 90s, divorce became a multi-billion-dollar industry involving lawyers, mediators, actuaries, and psychologists. The 661 number represents the precision of this modern machine. It is a system designed to process human emotion through a series of cold, legal filters. But as the 20th century closed and the 21st began, a new set of cracks started to appear. We began to see the long-term effects on the children of the divorce revolution. Data suggests that children from divorced households are 2 to 3 times more likely to experience psychological and social challenges. The legal system, which had successfully streamlined the exit for adults, was now faced with the monumental task of managing the fallout for the next generation. Why does this history matter to you in 2026? Because the laws governing your life today are the direct result of these historical battles. Whether you are married, single, or somewhere in between, the 661 evolution has defined your property rights, your parental rights, and your economic security. We have moved from a society that enforced marriage to a society that facilitates divorce. But what happens when the system becomes too efficient? What happens when the ease of exit begins to undermine the stability of the entire social structure? In the next part of this masterclass, we are going deeper. We are going to look at the secret tax codes that changed in the 1980s that made divorce a financial weapon. We will explore how the concept of the breadwinner was legally dismantled, and how a single court case in the mid-80s changed the way every single American retirement account is handled during a split. You think you know how your 401k or your house is protected, but the 661 era rewritten those rules while most people weren't looking. The next chapter is about the money, the power, and the silent theft of the American middle-class legacy. Do not miss what comes next. The shift from moral culpability to mathematical calculation in the 1980s turned the American courtroom into a laboratory for forensic accounting. To understand the 661 evolution, we have to look at the exact moment the U.S. government decided that a marriage was no longer a sacred covenant but a complex financial merger. In 1984, 2 massive legislative shifts occurred that fundamentally rewired the middle-class legacy. These were the Retirement Equity Act and the Tax Reform Act. Before these laws, if you were a spouse who had stayed home to raise children while the other built a career and a pension, you were often left with nothing but a small monthly check that could end at any moment. The system was designed around the breadwinner model, but the 661 era demanded a system designed around asset liquidation. Imagine a man named Robert in 1985. Robert had spent 25 years working as a senior engineer for a major aerospace firm in Ohio. He had a robust pension, a 401k that was just beginning to grow, and a home with significant equity. When his marriage dissolved, Robert assumed his pension was his alone because his name was the only one on the account. He was wrong. The Retirement Equity Act of 1984 introduced the world to the Qualified Domestic Relations Order, or the QDRO. This is a specific legal mechanism that allows a court to grant a portion of a private retirement plan to an alternate payee, typically a former spouse. Step by step, the court would calculate the marital portion of that pension, which is the value earned from the date of the wedding to the date of the separation. For Robert, this meant that nearly 60% of his retirement future was sliced away in a single afternoon. This was a historical trend that shifted trillions of dollars in wealth over the next 4 decades, creating a new class of retirees who found themselves with half the resources they had planned for. At the same time, the Tax Reform Act of 1984 introduced Section 1041 to the Internal Revenue Code. This is a critical piece of the deep dive because it removed the immediate tax consequences of transferring property between spouses during a divorce. Before this, if you transferred a piece of real estate or a block of stock as part of a settlement, it could trigger a capital gains tax event that would gut the value of the settlement. Section 1041 made these transfers tax-free at the time of the swap, but it created a hidden trap. The person receiving the asset also received its original tax basis. If Sarah received the family home while Robert kept the liquid cash, Sarah might find herself years later selling that home and facing a massive tax bill because she inherited the low 1970s purchase price basis. This is how the 661 era began to favor the spouse who understood the tax code over the spouse who only understood the immediate cash value. Consider the landmark case study of O'Brien v. O'Brien in 1985, which remains one of the most controversial decisions in New York legal history. Michael O'Brien was a surgical resident who had finished his medical degree while his wife, Loretta, worked as a teacher to support the household. When they divorced shortly after he became a doctor, there were very few physical assets to divide. There was no house and no pension. However, the court ruled that Michael's medical license was a marital asset. The logic was that Loretta had invested in his future earning potential, and therefore, she was entitled to a percentage of the enhanced earnings that the degree would provide over the course of his career. This case study opened a Pandora's box. Suddenly, professional degrees, celebrity status, and even the goodwill of a small business were being appraised by forensic accountants. Potential outcomes for professionals shifted from simple asset division to a lifetime of sharing the fruits of their labor with a former partner. This period also saw the rise of the standardized child support formula. In 2026, we take for granted that an algorithm determines what a parent pays, but in the early 1980s, it was often left to the whim of a judge. The federal government, concerned about the rising cost of welfare for single parents, pressured states to adopt rigid mathematical guidelines. This was the industrialization of family law. It moved away from the specific needs of a child and toward a percentage of income model. If you were a father in 1988, you saw the legal system move toward a withholding model, where support was taken directly from your paycheck. This provided a level of consistency that had never existed, but it also stripped the nuance out of the family dynamic. By the time we hit the 1990s, the 661 framework was being applied to the very concept of the standard of living. Courts began to use sophisticated software to determine how much money a spouse would need to maintain the exact lifestyle they enjoyed during the marriage. This led to the double-dip controversy in business valuation. If a husband owned a consulting firm, the court would value the business as an asset to be divided, but then they would also look at the income from that same business to determine alimony. This meant the same dollar was essentially being taxed or divided twice by the legal machinery. For many middle-class families, the potential outcomes of these legal battles were so expensive that the only winners were the experts hired to argue over the math. In our current year of 2026, we see the digital evolution of these 1980s rules. Today, the battle is over cryptocurrency, non-fungible tokens, and digital intellectual property. The 661 era taught us that anything with a perceived value is up for grabs. Imagine if you are a content creator in 2026. Your YouTube channel or your digital likeness is now viewed by the courts in the same way Michael O'Brien's medical license was viewed in 1985. The historical trends show that as technology advances, the definition of property expands to capture any new form of wealth. The step-by-step process of discovery now involves digital forensics and blockchain analysis, but the underlying legal principles remain rooted in that 1984 pivot. What people often miss is the psychological toll of this commodification. When you turn a relationship into a series of line items on a spreadsheet, you change the nature of the relationship itself. The 1980s gave birth to the prenuptial agreement as a mainstream tool for the middle class, not just the wealthy. It was a defensive move against the very laws we are discussing. People began to realize that if the law was going to treat their marriage like a business, they had better have a contract before they started. This shift in the American DNA moved us toward a more transactional view of partnership, where every contribution was measured and every sacrifice was accounted for. As we look at the data from the last 40 years, the silent theft of the middle-class legacy becomes clear. The cost of two households, the legal fees, the tax traps, and the division of retirement accounts have prevented millions of Americans from accumulating the kind of generational wealth that was common in the pre-661 era. We have traded long-term stability for short-term autonomy, and the financial data of 2026 is starting to show the true price of that trade. But there is another layer to this story that most people are completely unaware of. It involves the way the government itself profits from this cycle. In the next part of this masterclass, we are going to look at the Title 4D funding system. This is the secret financial incentive that pays state governments to keep the divorce and child support machine running. We will explore how your local court might be receiving federal kickbacks for every dollar of support they collect, how this creates a system that is designed to keep families in conflict rather than resolution. This is the dark side of the 661 era, where the bureaucracy has a vested financial interest in the dissolution of the American family. You need to see how the money really flows between the state and federal government. Do not look away now. To truly grasp the 661 evolution, we have to follow the money trail that leads directly to the United States Treasury. While the previous eras were defined by moral judgments and forensic accounting between individuals, this current chapter of the century of change is defined by a massive, often invisible federal-state partnership known as Title 4D of the Social Security Act. Most Americans view child support in custody as a private matter between two former partners, but historical trends show that since 1975, the state has become an active financial stakeholder in the dissolution of every family unit. This is not a conspiracy. It is a matter of codified public policy designed to reduce the burden on the public purse, but the secondary effects have created a multi-billion-dollar enforcement industry that has changed the incentives of the American judiciary. Step by step, let us break down how this machine functions. In 1975, Congress passed the Title 4D legislation to ensure that non-custodial parents, primarily those whose families were receiving public assistance, were held financially responsible. The logic was simple. If the taxpayers are paying for a child's upbringing via welfare, the state should be able to sue the absent parent to recoup those costs. However, over the following decades, this mandate expanded from a welfare recovery program into a universal system that manages nearly every child support case in the country, regardless of whether the family has ever touched a cent of public assistance. Imagine a character named Marcus in the year 2026. Marcus is a mid-level manager in a tech hub who is navigating a standard divorce. He might assume the child support he pays goes directly to his former spouse for the benefit of their children. However, because his case is processed through the state's Title 4D agency, Marcus is now a data point in a massive federal reimbursement cycle. For every dollar the state of Marcus's residence spends on the administration of his case, the salaries of the clerks, the cost of the computer systems, the fees for the process servers, the federal government sends a 66% reimbursement check back to the state. This is known as the federal matching grant. It means the federal government covers the majority of the overhead for the state's divorce and support infrastructure. But the 66% match is just the baseline. The real engine of the 661 era is the incentive payment system. The federal government measures every state on 5 specific performance metrics: paternity establishment, the number of support orders created, the percentage of current support collected, the collection of past due debt or arrearages, and cost effectiveness. If a state performs well in these categories, they receive additional millions of dollars in bonuses from the federal government. This creates a historical trend where state bureaucracies are incentivized to maximize the number and the dollar amount of support orders. When the system's funding is tied to the volume of money it processes, the potential outcomes for a parent like Marcus shift. The system is no longer just a neutral arbiter. It is a performance-driven agency that needs high-dollar orders to maintain its own budget. Consider the case study of a typical state-level child support agency. In 2026, these agencies utilize advanced data mining tools to track employment, tax returns, and bank accounts in real time. If the state identifies that a parent's income has increased, the system may automatically trigger a review to increase the support order. While this is framed as a benefit for the child, it also helps the state meet its current collections and cost-effectiveness metrics, ensuring the flow of federal incentive dollars remains steady. In many jurisdictions, the very judges or hearing officers who preside over these cases have their salaries or the budgets for their courtrooms funded through these Title 4D grants. This creates a potential conflict of interest that most litigants never realize exists. The person making the ruling is part of an organization that receives more funding when more money is ordered to be paid. The most controversial aspect of this financial loop is the welfare reimbursement model. If a parent is on public assistance, such as TNF or temporary assistance for needy families, the state often requires them to sign over their rights to child support as a condition of receiving aid. When the non-custodial parent pays support, the state keeps that money to reimburse itself and the federal government for the welfare provided. In many states, only a tiny pass-through amount, sometimes as low as $50 or $100, actually goes to the family. The rest is absorbed by the state and federal budgets. This historical trend has turned child support into a form of hidden taxation for the lower-income population, where the money intended for a child is used to replenish the government's coffers. As we look at the data in 2026, the scale of this operation is staggering. We are talking about tens of billions of dollars in collections annually. Because the system is so efficient at collecting, it has also become a tool for social engineering. The 661 designation in certain regional codes often refers to the automated processing of these cases. If Marcus falls behind on his payments, the system doesn't wait for a human to review his situation. It can automatically suspend his driver's license, seize his tax refunds, and report him to credit bureaus. Step by step, the legal system has replaced judicial discretion with algorithmic enforcement. The potential outcomes of this automation are profound for the American middle class. Because the system is designed for high-volume processing, it often struggles to account for complex realities. If Marcus loses his job or suffers a health crisis in 2026, the debt, often referred to as arrears, continues to accrue at high interest rates. In some U.S. states, this interest rate is as high as 10 to 12%. This isn't just a penalty, it is a debt trap. Once a parent falls into significant arrears, the federal incentive metrics make it very difficult for the state to settle or reduce that debt, as arrearage collection is one of the 5 keys to state funding. The system becomes a debt collection agency that can never be satisfied, even if the family itself wants to reconcile or move on. This brings us to a critical realization about the century of change. We have moved from an era where the state made it difficult to get a divorce, to an era where the state has a financial incentive to manage the fallout of that divorce indefinitely. The bureaucracy has become a permanent third party in the American home. This infrastructure didn't appear overnight. It was built layer by layer through the late 20th century, fueled by the desire for administrative efficiency and fiscal responsibility. But in the process, we have created a machine that requires a constant supply of high-conflict, high-dollar cases to stay fueled. Why does this matter for the future of the U.S.? Because the 661 evolution is now moving into the realm of total digital surveillance. As we look toward the final parts of this masterclass, we will see how the financial incentives of Title 4D are being combined with emerging technologies to create a system of preemptive enforcement. We are going to look at how your digital footprint, your spending habits, and even your social media activity are being integrated into the child support and alimony algorithms of 2026. But there is an even deeper shift occurring. While the state is focusing on the money, the very concept of custody is being revolutionized by a new legal movement that is sweeping across the United States. It is a movement that threatens to dismantle the winner-take-all custody model that has dominated the last 50 years. In the next part, we will explore the default 50-50 revolution and how it is colliding with the Title 4D money machine. When the state's funding depends on one parent paying and the other receiving, what happens when the law says both parents are equal? This is the battle for the soul of the 21st century family. The clash between financial incentives and parental equality starts now. The collision between federal money and parental equality is where the 661 narrative takes its most dramatic turn in the year 2026. To understand why your local family court operates the way it does, we have to examine the death of the tender years doctrine and the birth of the 50-50 shared parenting revolution. For the better part of the 20th century, the American legal system operated under a biological bias known as the tender years doctrine. This was a judicial presumption that during a child's tender years, typically under the age of 7, the mother was inherently the more fit caregiver. It was a Victorian-era holdover that viewed the father primarily as a financial provider and the mother as the emotional bedrock. Step by step, this doctrine was dismantled throughout the 1970s and 80s as gender roles shifted, and the Supreme Court began to strike down laws that treated men and women differently based on stereotypes. However, the replacement for the tender years doctrine was something called the best interests of the child standard. While this sounded noble in theory, in practice, it granted judges nearly unlimited discretion. A judge could decide that because a father worked 40 hours a week and a mother worked 20, the best interest of the child was to be with the mother 80% of the time. This created the winner-take-all custody model that dominated the last 50 years. In this model, one parent is designated the primary residential parent, and the other is relegated to visitor status, typically receiving every other weekend and a few hours on Wednesday nights. This brings us back to our character David in the year 2026. Imagine David lives in a state like Florida or Kentucky, which recently passed landmark legislation making 50-50 equal parenting the rebuttable presumption. This means the judge must start with the assumption that the child will spend exactly half their time with each parent. For David, this is a revolutionary shift in his parental rights. But here is where the 661 evolution and the Title 4D money machine we discussed in the previous part create a massive systemic friction. Child support calculations in almost every U.S. state are tied to parenting time. If David has the children 50% of the time, and his income is relatively similar to his former spouse's, his child support obligation might drop to zero or a very nominal amount. Historical trends show that state child support agencies, which are funded by the federal government based on the volume of money they collect, have a natural bureaucratic resistance to 50-50 custody. When a court orders 50-50 custody with no child support, the Title 4D agency loses a collection point. It cannot report a high-dollar collection to the federal government, and therefore, the state loses out on its percentage of the federal incentive bonus. This has created a shadow battle in state legislatures across the country. On one side, you have parental rights advocates pushing for equal time. On the other, you have a coalition of bar associations and state agencies that argue 50-50 custody is too rigid or ignores the nuances of the child's needs. Let's look at a case study from the mid-2020s. In states that adopted a 50-50 presumption, The potential outcomes for families changed overnight. Data from Kentucky, which was an early adopter of this standard, showed a significant decrease in the number of high-conflict custody trials. Why? Because when both parents know the judge is going to start at 50-50, there is no prize to fight for. The incentive to win primary custody and the accompanying child support check is removed. However, the step-by-step reality of implementing this is complex. To rebut the 50-50 presumption, a parent must prove by preponderance of evidence that the other parent is unfit, citing specific issues like substance abuse, domestic violence, or severe neglect. This has shifted the nature of legal conflict. Instead of arguing over who is better, parents are now forced to argue that the other is dangerous, just to bypass the 50-50 rule and trigger the support payments. In 2026, this conflict has moved into the digital realm. We now see the rise of parenting time algorithms. These are software tools used by the 661 compliant courts to track the exact minute-by-minute location of children. If David is supposed to have 50% time but he is consistently 20 minutes late for exchanges, his former spouse can use that digital data to petition for a modification of timeshare. If his time drops to 45%, the Title 4D machine can instantly recalculate a support order. The system has become a high-stakes game of minutes and pennies. The care gap, the difference between the time a parent is scheduled to have and the time they actually spend, is now a major focus of forensic litigation. Imagine if your ability to see your child was tied to a quality of care score generated by an AI. In 2026, some jurisdictions are experimenting with mediator bots that review the communication between parents on apps like Our Family Wizard. If David's communication is deemed uncooperative or aggressive by the algorithm, it can negatively impact his standing in a custody review. This is the ultimate evolution of the 661 era, the total integration of behavioral data into the legal process. The state is no longer just looking at the math of the money, it is looking at the math of your behavior. This creates a paradox. We have finally achieved a level of legal gender equality, where fathers like David have an equal claim to their children. But we have placed this equality inside a financial system that is still designed to reward conflict and primary designations. The potential outcomes are a constant state of litigation light, where parents are perpetually monitoring each other for any slip-up that might shift the percentage of time and, consequently, the flow of money. The best interest standard has been replaced by the best algorithm standard. But what happens when the money itself becomes invisible? As we look at the financial data of 2026, we see a massive rise in off-platform wealth. While the 661 system is expertly designed to track W-2 wages and traditional bank accounts, it is struggling to keep up with the gig economy, decentralized finance, and under-the-table digital payments. The state agencies are finding that as they become more efficient at collecting from the middle class, the new economy is moving outside their reach. This is leading to a desperate expansion of government surveillance power. In the next part of this deep dive, we are going to explore the financial panopticon. We will look at how the 661 era is moving beyond your paycheck and into your private digital life. We will discuss the new laws that allow the government to freeze your digital wallets, seize your crypto assets, and even block your access to the internet if you fail to comply with a support order. You thought your private keys were private? In the eyes of the family court, there is no such thing as a secret. We are going to show you exactly how the digital asset seizure protocols work in 2026. The walls are closing in on the old ways of hiding wealth. Prepare for the most high-tech chapter of the century of change. The financial panopticon of 2026 is not a theoretical concept or a dystopian prediction. It is a live, functioning infrastructure that has fundamentally shifted the leverage in American family law. To understand the current 661 protocols, you have to realize that the wall between your private financial life and the state's regulatory gaze has effectively dissolved. Throughout the late 20th century, if a spouse wanted to hide assets, they might use offshore accounts, physical cash, or complex shell companies. These required expensive investigators and months of discovery to uncover. However, in the 2020s, the U.S. government accelerated the integration of financial technology into the judicial system, creating a real-time monitoring network that makes traditional asset hiding nearly impossible for the average citizen. Imagine Olivia in the year 2026. Olivia is a successful freelance consultant who has seen her marriage of 12 years come to an end. Like many in the modern gig economy, her income is fragmented. She receives payments through digital wallets, decentralized finance protocols, and traditional banking apps. Olivia might believe that her Ethereum holdings, tucked away in a non-custodial hardware wallet, are invisible to the court. She might think that because there is number 1099 form yet for a specific transaction, the 661 algorithm will overlook it. But she is operating on 20th century assumptions in a 21st century legal environment. Step by step, the 661 Digital Asset Seizure Protocol begins with the mandatory financial disclosure. In 2026, this is no longer a paper form you fill out by hand. It is a digital authorization that grants the court's AI-driven auditing software temporary read access to your entire digital footprint. When Olivia signs her initial filing, she is often unknowingly consenting to a deep packet inspection of her financial history. The software cross-references her reported income with her spending patterns. If the algorithm detects that Olivia is spending $5,000 a month on rent and lifestyle expenses, but only reporting $3,000 in income, it triggers a lifestyle ledger discrepancy flag. This is the moment the financial panopticon tightens. The historical trends leading to this point are rooted in the 2021 Infrastructure Investment and Jobs Act, which expanded the definition of a broker to include almost anyone facilitating digital asset transfers. By 2026, this has evolved into a comprehensive reporting requirement where every US-based exchange, and even many decentralized front ends, are required to report suspicious asset shifting during active litigation. The court doesn't need to find Olivia's hardware wallet. It only needs to find the on-ramps and off-ramps. The moment she converted US dollars into crypto or vice versa, the software maps the blockchain, following the digital crumbs from a known exchange account to her private wallet addresses. Consider the case study of a 2025 litigation in Texas where a spouse attempted to move $200,000 into a privacy-focused cryptocurrency just 48 hours before filing for divorce. The court's automated 661 system detected the large transfer and immediately issued an electronic freeze order to the spouse's primary bank and all linked fintech apps. Within minutes, their ability to use Venmo, PayPal, or even their Apple Wallet was suspended. This is the digital hammer. In the past, you could still buy groceries with a credit card while fighting over a bank account. In 2026, the state can effectively debank you as a method of compelling financial transparency. The potential outcomes for Olivia are stark. If the court determines she is willfully non-disclosing, the judge can apply the imputed income trap. This is one of the most powerful tools in the 661 arsenal. If the court can't find the exact amount of hidden money, they simply look at Olivia's professional qualifications, her past earnings, and her current lifestyle to invent an income figure. If they decide she has the potential to earn $10,000 a month, her support and alimony obligations are calculated based on that fictional $10,000, regardless of what she actually has in her bank account. This creates a debt that is legally enforceable and nearly impossible to discharge in bankruptcy. Furthermore, we must examine the role of forensic blockchain analysis in the modern courtroom. In the 1990s, you hired an accountant. In 2026, the 661 expert is a data scientist who specializes in chain walking. These experts use sophisticated software to identify wash trading or tumbling techniques designed to obscure the source of funds. Historical trends show that as the complexity of hiding wealth increases, the state's appetite for surveillance grows to match it. We are now seeing the integration of social media data into this financial audit. If Olivia posts a photo of herself at a high-end resort in Tulum while claiming financial hardship, the AI will scrape that metadata, geolocate the resort, and estimate the cost of the stay, adding it to the evidence of her actual financial standing. The psychological impact of this total transparency is changing how Americans view marriage. We are seeing a historical trend toward financial segregation within marriages. Couples in 2026 are increasingly maintaining entirely separate lives, not out of a lack of trust, but as a defensive posture against the 661 machine. They are essentially pre-divorcing their finances from day one. This transactional approach to partnership is the direct result of a legal system that has become too efficient at asset liquidation. When every transaction is a potential piece of evidence, spontaneity dies. But the 661 evolution doesn't stop at your bank account. It extends to your future wealth. We are now seeing courts attempt to value digital influence and personal brands. If Olivia has a significant following on a social platform, that influence is now being treated as a marital asset with a projected future value. Step by step, The court calculates the growth of her brand during the years of the marriage and assigns a dollar value to it that her spouse may be entitled to a portion of. This is the ultimate commodification of the self. Your very reputation and your ability to earn in the future are being sliced into percentages. What is truly startling is the international reach of this system. Under the updated 2026 Hague Convention Protocols for Digital Asset Recovery, the U.S. government can now cooperate with over 60 other nations to track and seize assets held in foreign jurisdictions with unprecedented speed. The offshore haven is a dying breed. The potential outcomes for those who try to flee the jurisdiction are increasingly global, as your digital identity can be flagged at border crossings and international financial hubs. As we move toward the final chapters of this masterclass, we have to ask, who is actually benefiting from this level of surveillance? Is it the children? Is it the innocent spouse? Or is it the multi-billion-dollar enforcement industry that we discussed in Part 4? The efficiency of the 661 system has created a paradox. It has made the process of divorce more fair in terms of asset division, but it has also made it so expensive and invasive that the middle class is being priced out of their own justice. In the next part, we are going to look at the industry of conflict. We will explore the specialized roles that have emerged to feed the 661 machine, the mediators who use game theory to force settlements, the parental coordinators who function as private judges, and the soaring costs of the standardized divorce. We are going to reveal why, in 2026, a simple divorce can cost more than a 4-year college degree, and where that money is really going. This is the era of the professionalized split, and you need to know how to protect yourself from the experts who are trained to profit from your transition. The machine is hungry, and in Part 7 we show you how it eats. The machine is hungry because it has evolved from a simple legal process into a sprawling multidisciplinary economy that thrives on the very friction it claims to resolve. In the year 2026, the American divorce industry is no longer just about lawyers and judges. It is a specialized ecosystem of parental coordinators, forensic psychologists, vocational experts, and private arbitrators. This is the era of the professionalized split, where a standard contested divorce in a major U.S. metropolitan area can easily reach a total cost of $80,000 or more, rivaling the price of a 4-year degree at a state university. To understand why this is happening, we have to look at how the 661 framework has commodified every single disagreement between two people. Imagine a couple named Christopher and Jessica. They are a typical upper-middle-class American family in 2026. Christopher is a software architect, and Jessica is a healthcare administrator. They have 2 children, a suburban home, and a diversified portfolio of traditional and digital assets. When they decide to part ways, they enter a system that is designed to peel back every layer of their lives, and each layer comes with a billable expert. Historical trends show that as the legal system became more complex, it offloaded its decision-making power onto these third-party professionals. This is where the concept of the parent coordinator or PC comes into play. In 2026, many family courts in states like California, Texas, and New York are so backlogged that they essentially force high-conflict couples to hire a private parent coordinator. Imagine if you and your former spouse could not agree on which summer camp your child should attend, or whether the child should have a specific medical procedure. Instead of waiting 6 months for a judge, you are ordered to pay a PC, who often bills at $400 to $600 an hour. The PC has quasi-judicial immunity and the power to make binding decisions. For Christopher and Jessica, a simple dispute over a holiday schedule that should have taken 10 minutes to resolve can turn into a 4-hour session with a PC, costing them over $2,000. The machine eats by turning parental communication into a professional service. Step by step, the industry has also institutionalized the role of the forensic psychologist. In the early 20th century, a judge might have just looked at the parents and made a gut decision. In 2026, the 661 protocols often require a comprehensive custody evaluation. This is a process that can take 6 months and cost $15,000 to $30,000. The psychologist conducts multiple interviews, performs standardized personality tests like the MMPI-3, observes the parents with the children, and interviews teachers and doctors. While the goal is to determine the best interests of the child, the potential outcomes often lead to a war of the experts. If Christopher doesn't like the results of the first evaluation, his attorney might hire a second expert to critique the first one. This is the expert witness industrial complex, where the complexity of the human mind is used to generate endless billable hours. Another specialized role that has seen a massive rise is the vocational expert. Remember our discussion about imputed income? If Jessica decided to take a lower-paying job to have more time with the kids, Christopher's legal team might hire a vocational expert to prove that Jessica is underemployed. This expert will conduct a labor market analysis of the U.S. in 2026, looking at salary data for healthcare administrators, and produce a report stating that Jessica could be earning $20,000 more than she currently is. The court then uses this hypothetical number to calculate support. The fee for this report? Anywhere from $3,000 to $7,000. The machine eats by quantifying human potential and selling it back to the litigants as evidence. Then there is the financial side, the forensic accountant. As we discussed in Part 6, the financial panopticon makes hiding assets difficult, but analyzing them is still a manual, expert-driven task. In a 661 compliant divorce, every Venmo transaction, every crypto swap, and every business expense is scrutinized. For someone like Christopher, who has equity in a tech startup, the valuation of that equity is a battlefield. A forensic accountant must be hired to perform a lifestyle analysis to ensure no income is being diverted. Case studies show that in complex cases, the cost of the accounting alone can exceed the actual value of the assets being disputed. This is the paradox of the professionalized split. The cost of the process can consume the very wealth that is being divided. The industry uses game theory to manage these settlements. Lawyers often use a strategy called interest-based bargaining, but in a high-stakes 661 environment, it often feels more like a war of attrition. The goal is to reach the BATNA, the best alternative to a negotiated agreement. If the cost of going to trial is projected to be $50,000, the machine pressures the parties to settle for something slightly less painful. However, because the system is so professionalized, the settlement itself often involves complex legal structures like trusts, QDROs, and intricate parenting plans that require even more professional management over the long term. Historical trends indicate that this professionalization has created a middle-class squeeze. While the very wealthy can afford these experts and the very poor may have access to legal aid or simplified administrative tracks, the American middle class is often forced to liquidate their savings or take on debt to fund their own divorce. In 2026, we are seeing the rise of divorce litigation funding. Companies that lend money to litigants to pay for their experts in exchange for a percentage of the final settlement. This turns the dissolution of a family into a venture capital-backed investment. Why does the machine prefer conflict? Because conflict is the only thing that justifies this level of professional intervention. If Christopher and Jessica were to sit down and agree on everything in one afternoon, the industry would lose tens of thousands of dollars in potential revenue. While most professionals in the field are well-intentioned, the systemic incentives are built around billable hours and the standard of care that requires leaving no stone unturned. Every what-if scenario a lawyer raises, every precautionary evaluation a judge orders, and every detailed report an expert writes adds another layer of cost to the American family legacy. By the time the final decree is signed, many families in 2026 find themselves with significantly less than they started with, not just because they divided their assets, but because they paid a small army of professionals to help them do it. This is the hidden tax of the century of change. We have moved from a system that was legally difficult but relatively inexpensive, to a system that is legally easy but financially devastating. The freedom of no-fault divorce has been replaced by the servitude of professionalized litigation. But there is an even more profound shift happening under the surface. As we have professionalized the split, we have also begun to algorithmize the children. While the experts are busy with the money and the custody schedules, a new generation is growing up inside this high-tech, high-conflict machinery. In the next part of this masterclass, we are going to look at the children of the algorithm. We will explore how the data collected during these 661 divorces is being used to predict the future behavior of the next generation, and how the digital shadow of a parent's divorce follows a child through their own adult life. The machine isn't just eating your money, it's beginning to map the future of your children. Part 8 explores the psychological and digital legacy of the 661 era. Do not miss this. The psychological and digital legacy of the 661 era is perhaps the most profound transformation in the American social fabric, because it is the first time in history that a child's entire developmental environment has been codified, tracked, and archived by the state. When we talk about the children of the algorithm, we are talking about a generation that has grown up as data points within a high-stakes legal framework. In 2026, the residue of a divorce does not simply fade away after the final decree is signed. Instead, it forms a permanent digital shadow that follows the child into adulthood, influencing their social standing, their psychological health, and even their future economic opportunities. Imagine Leo, the 12-year-old son of Christopher and Jessica, whom we followed in the previous chapter. In the year 2026, Leo's life is governed by a court-ordered calendar that exists on a shared cloud-based platform. Every time Leo is dropped off at his father's house, a GPS-verified check-in is logged. Every time his mother pays for his soccer cleats, a digital receipt is uploaded to a 661 compliant reimbursement portal. Leo is aware of this. He sees his parents interacting through the cold interface of a screen, knowing that every word they type is being monitored by a parental coordinator or an AI-driven sentiment analysis tool. This is the first step-by-step reality of the digital legacy, the elimination of privacy within the family unit. Let's dive deeper into the 50-50 shared parenting reality for someone like Leo. While equal time is often the goal for parental fairness, the logistics in 2026 are grueling. Leo lives a suitcase life. He moves between households every 2 to 3 days to satisfy the rigid requirements of a 661 compliant parenting plan. He has 2 sets of clothes, 2 sets of chargers, and 2 versions of himself. Step by step, the child becomes a nomadic citizen within their own family. Data from developmental psychologists in 2026 indicates a rise in transition anxiety, where children struggle to find a sense of center when their environment is constantly shifting to meet the demands of a legal compromise. The focus is often on the parent's right to equal time rather than the child's need for a stable home base. There is also the intergenerational transmission of the 661 mindset. Historical trends indicate that children of divorce are more likely to divorce themselves, but the 661 era adds a new layer to this. These children are growing up with a transactional view of relationships. They see love and care being quantified into billable hours, percentages of time, and digital receipts. They are learning that the state is the ultimate arbiter of family disputes. In 2026, we are beginning to see the first wave of 661 adults entering the dating world. Case studies show they are significantly more likely to demand prenuptial agreements and maintain separate digital wallets from the very start of a relationship. They are applying the defensive, data-driven logic of their parents' divorce to their own romantic lives. The potential outcomes for the American social structure are massive. We are moving toward a society where the family is no longer an autonomous unit, but a monitored department of the state. The efficiency of the 661 system has made it easier to dissolve a marriage, but it has made it harder to raise a child outside of the shadow of the law. The professionalization of the split means that the experts are now a permanent fixture in the upbringing of millions of American children. These children are the primary stakeholders in the history of change, yet they are the ones with the least amount of agency in the process. Think about the sheer volume of data being generated. In 2026, every 661 compliant court in the US is generating terabytes of metadata on child behavior, parental cooperation, and financial flows. Who owns this data? Is it being used to refine the algorithms that will govern the next generation's divorces? Historical trends suggest that the more data a system has, the more it seeks to control. We are entering an era of algorithmic parenting, where the law doesn't just react to problems but attempts to prevent them by micromanaging the child's life through the divorce decree. As Leo grows up, his identity is inextricably linked to the 661 process. He is not just Leo. He is the subject of case number 2026-661. His milestones, graduations, first jobs, marriages, will all be filtered through the lens of the financial and legal obligations established during his parents' split. The machine has mapped his future, and while it provides a level of financial certainty that the previous century lacked, it has done so by sacrificing the intangible, unquantifiable elements of a childhood free from the state's gaze. But there is one final frontier we have yet to explore in this masterclass. While the US has been perfecting the 661 system, the rest of the world has been watching, and in some cases they are moving in a completely different direction. In the next part of this deep dive, we are going to look at the international escape. We will explore how different cultures are reacting to the Americanization of divorce, and what happens when the 661 machine hits the wall of international sovereignty. We will look at the rise of divorce sanctuaries, and the growing movement of parents who are opting out of the digital panopticon entirely. The century of change is reaching a global tipping point, and the clash between the American algorithm and the rest of the world is about to ignite. Part 9 looks at the global endgame. Stay tuned. The clash between the American 661 algorithm and the boundaries of international sovereignty is the final great friction point of the century of change. While the United States has spent the last century perfecting a high-speed, data-driven machine for dissolving marriages and managing families, the rest of the world has not moved in lockstep. In the year 2026, we are witnessing a phenomenon known as the global legal drift. As more Americans live, work, and invest abroad, the reach of the U.S. family court system is hitting a wall of national resistance. The financial panopticon and the Title 4D enforcement machine that we have dissected are now attempting to operate on a global scale, and the results are explosive. Imagine Elena in the year 2026. Elena is a dual citizen of the United States and Italy, working as a high-level executive for a European tech firm. Her marriage to a U.S. citizen ended in a California court under the full weight of the 661 protocols. The court ordered 50-50 custody and an aggressive child support plan based on her international salary. However, Elena has moved her base of operations to a jurisdiction that does not recognize the automated, algorithmic nature of the U.S. decree. In her new home, the local courts view the American system as a violation of her fundamental privacy rights. Elena has entered a divorce sanctuary. Historical trends show that since the early 2000s, the primary mechanism for handling these disputes has been the Hague Convention on the Civil Aspects of International Child Abduction. Originally drafted in 1980, the Hague Convention was designed to prevent one parent from fleeing to another country to find a more favorable court. But by 2026, the 1980 framework is buckling under the pressure of the 661 era. The U.S. government, driven by the financial incentives of Title 4D that we discussed in Part 4, has pushed for more aggressive international enforcement. The potential outcomes of this pressure have led to a backlash from sovereign nations that refuse to turn their local banks and social systems into extensions of the American judicial machine. Step by step, let us examine the International Enforcement Protocol of 2026. If Elena stops paying the U.S. order support or refuses to comply with the minute-by-minute tracking of the 50-50 parenting plan, the U.S. State Department has a specific set of tools at its disposal. The first tool is the Passport Denial Program. Under current U.S. law, if a parent owes more than $2,500 in child support, their passport is automatically flagged and can be revoked or denied. In 2026, this digital flag is shared via international police databases. When Elena attempts to cross a border in the Schengen area, her U.S. passport may be electronically killed, effectively trapping her or forcing her to use a second nationality. This is the 661 reach, extending its digital fingers across the Atlantic. However, the case study of the 2025 Singapore-US dispute illustrates the limits of this power. In this instance, a U.S. court attempted to garnish the crypto assets of a resident in Singapore based on a 661-style forensic audit. The Singaporean authorities blocked the order, ruling that the American algorithm's reliance on imputed income and digital surveillance did not meet their standards of due process. They argued that the American system had become so automated that it no longer provided a human judicial review. This was a landmark moment in the century of change. It signaled that the world's financial hubs were beginning to view American family law as a form of legal imperialism. The potential outcomes for the American middle class in 2026 are increasingly complicated by this global rift. Imagine if you are a digital nomad, earning income in various currencies and living in a rotating series of countries. The US 661 system assumes you have a stable, traceable W-2 income. When the system tries to apply its rigid formulas to your nomadic lifestyle, the friction creates massive legal debt. We are seeing a historical trend of Americans opting out of the U.S. system by renouncing their citizenship or moving their entire wealth into jurisdictions that have no reciprocity treaties with the U.S. These are the new divorce sanctuaries. Countries like the United Arab Emirates or certain Caribbean nations that offer a shield against the financial panopticon. The 661 era is also colliding with different cultural definitions of the best interest of the child. In many parts of the world, the American 50-50 model is viewed as a form of legalized instability. In 2026, we see case studies from Japan and Brazil where courts have refused to return children to the U.S., arguing that the American system's focus on mathematical equality between parents ignores the cultural and emotional stability provided by a single primary residence. These nations are effectively rejecting the child of the algorithm model we discussed in Part 8. They are prioritizing human tradition over digital efficiency. This global endgame has created a three-tiered system of international family law. The first tier consists of the fully integrated zones, where the US and its closest allies share data in real time, making a 661 decree almost instantly enforceable. The second tier is the gray zone, where enforcement is a slow, manual process involving years of diplomatic negotiation. The third tier is the sanctuary zone, where the American 661 reach simply stops. For a high-net-worth individual or a professional with global mobility, the choice of where to live has now become a strategic decision based on the vulnerability of their assets and parental rights to the American machine. The data of 2026 shows a sharp rise in international custody arbitration. Because the state-to-state system is failing, wealthy families are increasingly turning to private, international firms to handle their splits. These firms use private contracts to bypass the 661 courts entirely, creating a shadow legal system for the global elite. Meanwhile, the average American family remains trapped within the domestic machine, unable to afford the international escape, and subject to the full weight of automated enforcement. Why does this matter for the final chapter of our masterclass? Because the global resistance to the 661 system is forcing the US government to double down on its domestic surveillance. As the money flees to international sanctuaries, the Title 4D machine must work harder to extract value from those who remain. This is leading to the final evolution of the century of change, the social credit model of family law. We are moving toward a future where your compliance with a divorce decree isn't just about money or custody. It's about your very ability to participate in the modern economy. As we conclude this deep dive into the global endgame, we see that the 661 phenomenon is no longer just an American story. It is a battle between the efficiency of the algorithm and the resilience of human sovereignty. The walls are not just closing in. They are being rebuilt at every border. But there is one final piece of the puzzle. What is the ultimate destination of this century-long journey? Where do we go from here? And is there any way to restore the human element to a system that has become a machine? In the final part of this masterclass, we are going to synthesize everything we have learned. We will look at the human restoration movement, the growing push to dismantle the 661 algorithms, and return to a system of localized human-centric justice. We will explore the new marriage models of the late 2020s, and show you how to navigate the future without being consumed by the machine. The century of change is ending, and a new era is beginning. The conclusion of the 661 deep dive starts now. Stay with us for the final part. The human element of the American family is currently engaged in a silent but massive counter-revolution. As we stand in the midpoint of 2026, the 661 machine has reached its peak efficiency, but it has also reached the limits of human endurance. This final chapter of the century of change is not defined by a new law or a fresh algorithm, but by the human restoration movement, a systemic pushback where individuals are intentionally opting out of the high-conflict industrial complex to reclaim the sovereignty of their private lives. To understand how to navigate this landscape, we must look at how the next generation is rewriting the rules of engagement before they ever step foot in a courtroom. Imagine Ethan and Maya, a couple in their late 20s starting their lives together in 2026. They are the children of the 661 era. They grew up watching the digital shadows of their parents' divorces stretch across decades. They saw the forensic accountant, parental coordinators, and the algorithmic custody schedules. Because of this, Ethan and Maya are not entering marriage with the wide-eyed idealism of the 1950s, nor the transactional coldness of the 1990s. Instead, they are utilizing what experts call preemptive resolution. Step by step, they are creating private, legally binding frameworks that prioritize human mediation over automated litigation. In 2026, the historical trend is moving toward the collaborative law model. This is a specific legal structure where both parties and their attorneys sign a participation agreement. This contract is the antidote to the 661 machine because it explicitly states that if the parties cannot reach a settlement and decide to go to court, both lawyers are disqualified from representing them further. This removes the financial incentive for attorneys to escalate conflict. For Ethan and Maya, this means their legal counsel is incentivized only for peace, not for the billable hours generated by a trial. Potential outcomes of this model include a 70% reduction in legal fees, and, more importantly, the preservation of the co-parenting relationship. Furthermore, we are seeing the rise of the lifestyle agreement. Unlike a traditional prenuptial agreement which focuses almost exclusively on asset liquidation, A lifestyle agreement in 2026 is a roadmap for the marriage itself. It codifies expectations for digital privacy, the use of social media regarding children, and even how disputes will be mediated. If a conflict arises, the agreement mandates a step-by-step process. First, private counseling. Second, peer-led mediation. And only as a final desperate resort, the entry into the state's 661 system. By creating these speed bumps, couples are protecting themselves from the digital hammer of the state's automated enforcement. The data of 2026 shows that this movement is not just about avoiding divorce. It is about redefining success. We are seeing a significant historical trend where the U.S. divorce rate, which spiked in the late 20th century, is beginning to stabilize among younger cohorts who use these restorative models. Case studies from the restoration circles in states like Oregon and North Carolina reveal that when families utilize community-based arbitration, the psychological toll on children like Leo, whom we discussed in Part 8, is dramatically lowered. These circles involve a panel of neutral community members who focus on restorative justice rather than punitive mathematical formulas. It is a return to the human scale of justice that existed before the 661 industrialization. However, navigating the future still requires a sophisticated understanding of the 661 machinery that remains in place. For those already within the system in 2026, the key to resilience is data transparency. The financial panopticon thrives on the discrepancy flag. When a litigant attempts to obscure a transaction or hide a digital asset, the algorithm intensifies its surveillance. In contrast, the most successful potential outcomes in modern family law are currently found by those who practice over-disclosure. By providing the machine with total, organized, and voluntary data, litigants can often bypass the most invasive forensic stages of the process, saving tens of thousands of dollars in expert fees. We must also look at the evolution of support in this new era. The Title 4D machine is still hungry for collections, but a new wave of legislators is pushing for the child-centric spending model. In this scenario, instead of money being transferred to a parent to be spent at their discretion, which often fuels conflict over how the money is used, the funds are placed into a restricted family account, accessible to both parents only for verified child-related expenses. This uses the 2026 fintech infrastructure to ensure that every dollar ordered by the state actually reaches the child, removing the hidden tax and the alimony in disguise arguments that have plagued the last 50 years. The century of change has brought us from a world where you couldn't leave a marriage to a world where you can't escape the paperwork of one. But as we reach the conclusion of this masterclass, the lesson is clear. The law is a tool, but it is not a cure. The 661 system was designed to handle the average case through average formulas, but no family is average. The families who are thriving in 2026 are those who treat the legal system as a secondary safety net, rather than a primary resolution tool. They are building legal firewalls around their homes through private contracts, trust structures, and mediation-first protocols. Imagine if the next century is defined not by the 661 of the machine, but by the 360 of the human, a full-circle return to viewing the family as a unit of people rather than a unit of production. The historical trend suggests that we are at the dawn of the post-adversarial era. The professionalized industry of conflict is facing a market correction, as the American public realizes that the cost of winning a divorce is often higher than the value of the assets being fought over. Step by step, the U.S. is moving toward a system that values the social capital of a stable family transition as much as it values the financial capital of the settlement. Your role in this future is one of informed agency. Whether you are entering a union, navigating a split, or supporting a child of the algorithm, your greatest asset is literacy. Understanding the tax codes of 1984, the financial panopticon of the 2020s, and the restoration movements of 2026 allows you to move through the machine without being crushed by its gears. The machine is only as powerful as the conflict you feed it. When you choose mediation, when you choose transparency, and when you choose the long-term health of the next generation over a short-term legal victory, the 661 algorithm loses its grip. The century of change is not over. It is simply entering its most human phase. The era of the professionalized split is being challenged by the era of the conscious transition. We have moved through the fire of the fault system, the chaos of the no-fault revolution, and the cold efficiency of the algorithmic era. Now we are left with the most important question of all. How will you choose to define your legacy in a world that wants to define it for you? This concludes our deep dive into the 661 evolution. But while this masterclass ends here, the real-world application of these lessons is just beginning. In our upcoming series, we are going to look at the wealth of the single parent, a deep dive into the new economic models of 2027 that are allowing families to rebuild generational wealth faster than ever before. We will look at the co-parenting corporations and the new tax loopholes designed for the modern American household. The machine is changing, and we will be there to map it. Your journey into the new era of family and finance continues. Stay ahead of the curve.